I'm Chuck Harrison, here on behalf of Ms. Gunn. Here she comes.
All right.
She's joining us in court today.
Thank you. Ms. Gunn is currently in pretrial custody and is now being escorted to the defendant's table. Thank you. You may have a seat, ma'am. We're here today for an initial pretrial conference. I conducted that a little while ago in chambers with the counsel. And they informed me that they intend to enter a pretrial agreement. Ms. Dahl?
Yes, Your Honor, the people have offered that if the defendant were to plead no contest to attempt malicious destruction of building 1,000 to 20,000, the people would dismiss count 1, which is malicious destruction of building 1,000 to 20,000.
Mr. Harrison, is that a complete and accurate statement of the pretrial agreement?
It is indeed, Your Honor.
Ms. Gunn, is that how you wish to resolve today's file?
Yes.
Thank you. Madam Court Reporter, if I could please have an exhibit sticker.
Ask a question if you got one. Okay.
Ms. Gunn, to the best that you can, please raise your right hand. Do you swear or affirm that the information and testimony that you're about to provide shall be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. You may lower your hand. Ms. Gunn, back on May 26th of 2021, were you on probation, parole, or bond?
I was on probation.
Okay. And was there a probation violation taken here, Mr. Harrison?
There was in
Reed City.
Osceola County.
Okay, I get them confused all the time. I knew it was Reed City.
Are you off of probation now?
Yes.
Yeah,
All right,
that's
thank
been
you.
resolved.
I just need to make sure I know, because if you still were on probation, then there could be a probation violation, but I don't need to go over that now. All right, Ms. Gunn, you are currently charged on a piece of paper that's called a felony information, and on it you're charged with 1 count. That 1 count is a charge of malicious destruction of a building and a value of $1,000 or more, but less than $20,000. That is a felony punishable by up to 5 years and or up to $10,000 or 3 times the value of the destruction or injury to the building. Now that count will be dismissed if you enter a plea of guilty to, and I accept that plea, to attempt malicious destruction of a building of a value of $1,000 or more, but less than $20,000. In that instance, the maximum, it still remains a felony, and the maximum punishment is up to the same, no more than 5 years in prison, or, and pay attention, this is a little bit confusing. Most people get it confused, or up to 1 year in jail. Okay, so if you don't get a prison sentence, and has anybody run our guidelines?
I believe they're intermediate guidelines.
Okay.
I just need to offer this morning, so I haven't scored them at this.
I'm running as with the
Most likely.
plea right now, Your Honor.
Do you have any prior felony convictions?
No.
All right. Most likely I can predict that the guideline range is going to be about a 0 to 11 or a 0 to 17, which is what we call an intermediate sanction cell. And so when I told you that this still is a felony and it's still punishable by up to 5 years in prison, but because of the guidelines, it would be something less than up to a year in jail. I'm not saying that's what the sentence will be, but I just need to let you know what the punishments could be. Okay. All right. Anyways, now by entering a plea of guilty, you'll be waiving certain rights and not have a trial. Does that make sense?
Yes.
Mr. Harrison provided to me a piece of paper that at the top says advice of rights, and I'm holding it up for you. At the bottom, it appears to have your signature. Is that your signature, Ms. Gunn?
Yes.
Now, before you signed it, did you read through these rights?
Yes.
Did you understand what you read?
Yes.
And even more importantly, you understand that if you plead guilty, and I accept that plea, you'll be waiving these rights as they apply to this particular case.
Yes.
Additionally, you'll be foregoing the right to claim that the plea was a result of some promise, threat, or inducement not told to me today on the record. Have there been any other promises, threats, or inducements about anything to get you to plead guilty that we haven't talked about?
No.
Are you entering the plea of your own free choice? Now, Mr. Harrison has probably talked to you about Michigan sentencing guidelines and try to give you an idea as to what those would be. And we just kind of talked a little bit about them. I told you that it sounds like your guideline range would be a 0 to 17 or a 0 to 11. I need to let you know that that's just an estimate right now because we haven't run them through the Department of Corrections yet. The key is also they are merely a guideline. They are not a mandatory sentence. So it's still within the court's discretion. And they are, however, a valuable tool that courts must use. Now, Mr. Harrison is probably also trying to give you an idea as to what he thinks I would do because he appears in front of me a lot. So I just need to let you know that whatever he's told you, it's my job to decide what the sentence is. Whatever he's told you is just an estimate. That's what he's supposed to do, so you have an idea of what you're doing and the possible consequences. Do you understand?
Yes.
All right. No, knowing that, do you still wish to enter the plea of guilty that we talked about?
Yes.
I'm sorry, no contest. No contest. If I have, and I need to let you know, a no contest plea has the same impact as a guilty plea. You're waiving all the same rights. The only difference is instead of requiring you to state on the record the basis for the plea, I'm going to look at something else. Do you understand?
Yes.
All right. Do wish to enter the plea of no contest?
Yes.
As to added count to attempt malicious destruction of a building between $1,000 and $20,000, how do you plead?
Guilty.
Oh,
Or no contest.
that's okay. That's all right. Happens all the time.
Yeah.
I often say, I'm going to ask you what your plea is, and I remind you, I anticipate it to be a no contest plea because everybody does what you just did. That's okay. So anyways, I have before me what's marked now as prosecution exhibit or people exhibit number 1, and it is the transcript from the preliminary exam that was conducted before the Honorable Judge Corey Wiggins in the 84th District Court back on November 25th and filed in this file on December 11th. Ms. Dahl, are you asking the court to accept that as an exhibit for the taking of the no contest plea?
Please, Your Honor.
Mr. Harrison, any objection?
None whatsoever.
And as I understand, the basis for the no contest plea is based upon potential civil liability. Is that correct, Mr. Harrison?
That is correct, Your Honor.
Any objection to that, Ms. Dahl?
No, Your Honor.
All right, thank you. People's exhibit number 1 is hereby admitted. Now, Ms. Gunn, I was told what the plea was going to be. Therefore, I've already read the transcript before you came in today, before I took the bench. All right, Ms. Dahl, do you believe that the interests of justice do not require the recitation of a guilty plea and facts from Ms. Gunn?
Yes, Your Honor.
Mr. Harrison, do you agree?
Of course.
Ms. Dahl, do you believe that this exhibit provides a factual basis for the acceptance of the plea?
Yes, Your Honor.
Mr. Harrison?
I do as well.
Ms. Dahl, are you aware of any other promises, threats, or inducements?
No, I'm not.
Mr. Harrison?
I am likewise unaware.
And Ms. Dahl, do you believe that the court is in compliance with Mission Control 6.302?
Yes, Your Honor.
Mr. Harrison?
You are.
Thank you. The court agrees that the interests of justice based upon potential civil liability does not require a guilty plea or recitation of the facts from the defendant. Therefore, the court also finds that People's Exhibit number 1 satisfies the elements for the added count 2. The court finds the defendant's plea today is made freely, knowingly, and voluntarily. The court further finds stated the exhibit contains all the facts necessary. Therefore, the defendant is found guilty of added count 2. Count 1 will be dismissed at the time of sentencing. Ms. Gunn will be back here for sentencing in about 4, maybe 5 weeks. We do sentencings every Monday morning in this courtroom. Between now and then, an agent from that Department of Corrections, also known as the Probation or Parole Office, is going to prepare a pre-sentence investigation report. One of these reports must be prepared and submitted to the court anytime someone is convicted of a felony here in the state of Michigan. That requires 3 steps or 3 parts for you to be aware of. Number 1, you're going to get a packet. The clerk's already handed it to the bailiff. And when you leave here, you'll get it, open it up, follow the instructions, complete all the information to the best that you can. Turn it in. Second, you'll be subject to an interview with an agent from that office, and you have the right to have Mr. Harrison present during that interview. And number three, about 10 days, maybe 2 weeks before, Mr. Harrison and myself and Ms. Dahl will each get our own copy of that report. And Mr. Harrison's going to have to come and meet with you and go over the contents of that report, because each side has the right to come back here, make objections to the content, see if there's something that's wrong, maybe make a correction. Sometimes there's an error in there that needs to be corrected. So he needs to go over it with you. Do you understand?
Yes.
All right. And sometimes you'll fill it out and you'll forget something. And then next time Mr. Harrison will bring it and you go, oh yeah, that's right. I was living there at that time. And you might have something to change. Okay. It will also include this report will include a description of the event, description of the pretrial agreement, statements that you make or provide while it's being prepared, statements from any victim if he or she so chooses. It will include a scoring of the guidelines, which again, I already told you are not mandatory, but they are an important tool the court must use. It will also include a recommendation as to the sentence. Please keep in mind, it is merely a recommendation, as I'm the one that determines the sentence. Now, when I was a defense attorney, I could always, in certain counties, predict that the judge would go along exactly word for word with the recommendation. I can tell you, I don't think anybody will do that with me because I make my own decisions. Okay?
Okay.
All right. Thank you very much. Anything further from the people, Ms. Dahl?
Yes, Your Honor, does the order for DNA sample get signed now or at sentencing?
Yeah, do you have it? Thank you.
I mean,
Yeah, you may. This means that you don't have any felonies, right?
Yeah.
Which you already told me. So, Ms. Gunn. Are you here? You're here at the Wexford jail, right? You weren't brought up here from someplace else.
I was, yeah, I was,
She's kind of bounced back and forth throughout it, but you're staying here now, right?
yeah, I'm in Wexford County,
Yeah.
but I live in Davidson.
All right. So. It has to be done when someone's first convicted of a felony. They take a DNA swab. It's an uninvasive swab of your cheek. It's done anytime every time someone's convicted of a felony for the first time in a state court here in Michigan. Karen, if you could please grab this, give the copies.
Goldenrod and the canary.
Pink goes to Ms. Dole, the other two go to Mr. Harrison. All right. Mr. Harrison, I heard you making some chit chat. Go ahead and tell me what you want to ask.
I take back whatever I had said.
Okay.
We were gonna ask for a reduction amount. It's only at $1,000 right now.
Oh.
I don't think it's even worth. She can post that if she needs to.
All right. Thank you very much. Anything else, Ms. Dahl?
no, Your Honor.
Thank you. Ms. Gunn, do you have any questions about what we have done today?
No, sir.
All right, great. Thank you. We should see you in about a month on a Monday. Okay. We are here today, I think, for an initial pretrial conference. We have joined us today via Zoom an Assistant Attorney General. Ma'am, your appearance.
Good morning, Your Honor. Abigail McIntyre appearing on behalf of the people, P71143.
Thank you.
I'm Jeff Harrison. I'm here on behalf of Wesley Ann Cotter. She's joined me at the table.
Thank you. We are here today for an initial pretrial conference. What are we doing today, Mr. Harrison?
We have entered into some negotiations with regard to the resolution of the case. We're not there yet, Your Honor.
Are there any discovery issues that I need to, wag my finger at the prosecutor and say, pick it up or anything?
I can't imagine that there are. There has been voluminous discovery already exchanged.
Good. Any motions that I need to make a note of?
Other than motions in limine and a motion to adjourn trial and maybe a notice of other acts.
Sure.
Okay,
Well, I'll deal with those as they come up. Ms. McIntyre, what I do, and I know there was a stipulation to adjourn presented to the court. What I do is when we have final pretrials, typically I have about 6 to 10 of them scheduled on a given day. They're all set for trial on the same day, 10 days out. And as we all know here, between the three of us, we know that most cases go away and never go to trial. So, but also, I do a lot more trials than some of my predecessors, not because it's me, but it just seems to be that I'm doing more. So that also means that generally one still gets set for trial. So what I'm trying to tell you is I like to keep the case moving. Odds are it won't go to trial on that particular day. And as we get closer, I know that other cases, other trials elsewhere across the state get dismissed, get adjourned, get reset. So whether or not we have to adjourn the trial, I just like to make that decision a lot closer to that date of the final pretrial conference. Because I also want to keep everybody working on the file. Because I am also well aware that if I adjourn a trial, then this one slides off to the side and then another case comes up and we take some precedence, and that's okay. But I don't like to do that until I find that there's good cause for doing so. So I just wanted you to understand the reason for the denial. So I just find it to be a bit premature, but I understand why you're doing it, and I don't mind you making that request. So we don't have anything to cover today. Anything else, I'm sorry, to cover on the record as far as I know. Defendants on bond, and I don't see any issues here in the file. Anything else, Mr. Harrison?
I have nothing further. Thank you, Your Honor.
Anything else, Ms. McIntyre?
Nothing for the people, Your Honor.
All right, great. Thank you all very much. Hold on as I make some notes. All right. Thank you very much, Ms. Connor, for being here. We are adjourned.
Thank you. Have a good holiday.
You as well, ma'am. Thank you.